Bilal Abbasi is a policymaker working as Director IT in the Ministry of IT and Telecom based out of Islamabad. With prior experience of formulating Pakistan's digital policy, he is the youngest among members working on policies for data protection, cybersecurity, cloud computing, blockchain, and IoT. His remarkable work on digitization, governance, and collaboration has been recognized on regional and global platforms. He has represented Pakistan and its digital policy reforms at global forums like IGF and ICANN, and also served as an advisory for multiple social media companies and their reforms. Thank you so much for joining us, Bilal. Our second panelist is Jehan Ara. She is the founder and CEO of Katalyst Labs, which is a startup accelerator innovation hub and women leadership, and she is also associated with the Women Leadership Fellows Program. She is the former president of the Pakistan Software Houses Association for IT and ITES, PASHA. In January 2015, Jehan set up the Nest IO, a technology incubator, accelerator, and innovation community hub in Karachi, with the support of Google for entrepreneurs to help provide a platform for aspiring technology businesses in Karachi. Currently, Jehan serves as a member of the Prime Minister's Task Force for IT and Telecom, as a member of the APAC Content Advisory Board for TikTok, and is on the advisory boards of the Punjab IT Board, the Sindh IT Advisory Board, and on the Industry Advisory Board of various local organizations. Thank you so much for joining us, Jehan. So I'll direct my first question towards Bilal Abbasi sir. Bilal, could you tell us about when and why did the ministry decide to draft a data protection bill, and what the process has looked like so far?
Thank you very much, and I think it's a great opportunity for Ministry of IT to actually present its case to all of you, and at the same time I would like to thank all of you for organizing such a lovely event. This bill is actually what motivated us is an important thing. I think that currently if you look at the future or even the present of the digital economy, the data is the key, right? And we see that there are no certain norms or policies, procedures, regulatory regimes which can protect the citizens. That's the foremost important thing which came in our mind. And second important thing is, if international companies or businesses wants to come to Pakistan, they don't have the confidence that what exactly are the regulatory regimes in terms of data which can protect them and the citizens at the same time. So this was kind of a motivation to us. So back in 2017 or 2018, the first draft was presented, but that draft was probably not in line with the international best practices. So the new team joined in Ministry of IT in almost 2019, and we started working on this bill. So our bill is primarily more inclined towards GDPR, and if you see that, even if you look at the definitions, most of those definitions are related to GDPR. It's more influenced, but at the same time, local context is very important, and we incorporated the local context into it, because you see the situation in Pakistan is pretty different than the situation in Europe. So you have to incorporate those things, because we have some blasphemy laws, other minority laws which probably are not much. If you look at Europe, they probably don't care about those things. So I think what we have done is that in 2019 we prepared a bill, we presented it, we put that online, and we have done an extensive consultative process. Now, when I say that extensive consultative process, it's more like, the companies, international companies, local businesses, government organizations, and citizens, all of them participated. They've given their views and comments. And what we have done in response, we have not only read those comments, but we have had a meeting with all of them just to see that what exactly is the rationale behind those comments. So that is the inclusive approach that was adopted by the government. We wanted the stakeholders to be part of this policy making, on the preparation of this bill. So currently, if you ask us, that we have done 2 rounds of the consultative process, and our third bill is final from my side at least. It'll be just reviewed by our legal wing. We're hoping that in some time they'll finalize it, and then there is a whole step to sort of follow that. And maybe during the course of this panel discussion, I'll tell you more about it.
Fantastic. Thank you so much for a comprehensive answer, Bilal. I'll direct my next question towards you, Jehan Ara. Why do you think there is a need for a data protection bill in Pakistan? And जो current draft हमारा मौजूद है बिल का, आपके ख्यालात क्या है उसके बारे में?
So, I think there is a definite need for a data protection bill, and the reason for that is that data is now sort of used and created by everyone, and so there needs to be some protection, especially for the user of that data and the provider of that data. So a lot of us provide a lot of data. So Nighat told me not to mention this, but when I walked in, you guys collected my data at the entrance, my mobile number, my email address, which organization I was with. So I know Digital Rights Foundation is a responsible organization, and they will handle that data very responsibly. But this happens wherever you go, whichever event, whichever e-commerce outfit that you register with, a lot of data is collected, but nobody tells you what is going to happen to that data eventually. So I think a data protection bill is definitely necessary to provide the guidelines as to what happens, how long they can keep hold of that data, should they be destroying it. Another thing that I have personally been very concerned about is the use and collection of the data by large organizations, both public and private. So for instance, अगर आप देखें तो telcos के पास आपका सब data है ना, and then banks के पास आपका सब data है. When telcos collect your data, I have found that a lot of that data filters out to other people. And I get all these spam messages trying to sell me things. I get phone calls trying to sell me insurance policies and all sorts of. Where could they have got that information from? So I believe that maybe at a higher level, the telecom organization is being responsible, but at a lower level, their employees who are collecting this data are then, I suspect, selling it. And this is something that I have suspected for a long time, and that has been proven to be something that is partially true. Some of those employees are extremely responsible, but some are not. So why do you think that people should be able to collect that data and do with it what they wish? And this is why I am hoping that the data protection bill will provide guidelines that people will follow, so that my data is protected and I am protected, because it's not just me. Younger people especially, I feel, are at risk. You know, I can sort of protect myself, and perhaps I'm anyway pretty open to sharing everything on social media, and I'm told off by young activists all the time that you should not be doing that. But young people are more at risk, and you know, they don't think privacy is such an issue. So I think that, you know, whether it's banks, whether it's large organizations, I wanted to ask Tariq Malik, actually he gave us some information that I was not aware of that Nadra was doing. But I wanted to ask him that within Nadra, how is that transfer of data handled amongst Nadra employees? Because, you know, I have not read the Nadra Act, so I'm not aware of how that's handled. So he, as the leader, may have decided that this is what's going to happen. But what about the employees below him? What procedures do they follow? How do they take care of the data? What happens? So these are things that concern me.
And the current version of the data protection bill, how does that read to you?
So Bilal is absolutely right. It has undergone sort of 3 or 4 versions, and most of us, Nighat, myself, several of us have been involved in the consultations, and the current bill is pretty good. There are a few concerns that I still have, which maybe I'm unaware of, and Bilal can clarify, but one of the things that we were talking out just before we came onto the panel was the data localization part. That a lot of startups, a lot of entrepreneurs, a lot of tech companies feel that if we have to keep our data locally and cannot keep it in the cloud on Amazon and share it and use it for international work, then you are restricting the use that we can put that data to. That's one. Secondly, I think the consent part, I don't think anywhere in the bill does it say how is that consent going to be given. Is it going to be in writing? Is it going to be verbally? So I'd like some clarification on that, but otherwise it's a very good bill. Still a few, I think, terms that need to be clarified. National interest is something that still worries me, because is my personal interest very different from national interest? I'm a part of this nation, right? So these are terms that that are so vague that you can use them any which way you like. And today Bilal is there and may be very responsible and all of that, but tomorrow there might be somebody else. How am I going to be protected? So these are things that worry me, and I'm sure Bilal can clarify some of these things.
Thank you so much, Jehan. Bilal, would you like to counter any of the things Jehan said?
Sure. So there are a couple of things I would like to highlight. First, about the consent part, I think we always confuse 3-4 things. So one, personal data protection is about privacy. The security is a separate part. So that's why we have a separate policy that is called as a cybersecurity policy. And then we have another policy that is called as cloud policy, which is again a separate thing. So we have to differentiate between all three. We cannot look into this bill hoping that everything will be there. So you have to find it in different policies and bills. When you talk about consent, so if you see that we have clearly defined the consent part, but this is a primary legislation, right? You cannot actually have everything in it, because why we cannot put everything in the bill right now? I tell you the trickiest part now. So this bill is going to be finalized by Ministry of IT. Then it will go to the Law Division. From the Law Division, it will go to the CCLC. From CCLC,
And the CCLC is?
CCLC is a Cabinet Committee for Legislative Matters,
Okay.
right? From CCLC, it goes to the Cabinet Division, where Cabinet approves it. Then it goes back to the Parliament. Parliament sends it to the standing committees, their standing committee on IT. It approves, it goes back to the National Assembly, where it gets approved. The same procedure is adopted in in Senate, and then it goes to the President of Pakistan for promulgation. Let's just assume that we put something, and during the course of its implementation, we see that, okay, this thing should be changed. Just see the procedure we have to adopt again, this whole process. So what we do is, normally the policy maker in legislature, what they do is, they write the pointers, they give the broader direction to the bill, and then they give some responsibilities to the commission or the authorities which are going to be developed under this bill. So this is what we have done. The primary legislation might not cover everything, but then we have given powers to the commission, and mind you, this commission is an independent commission. Every single member of this commission will be from the private sector. So this commission is going to actually run the whole business of personal data protection. So another concern of the civil society was that there should not be much involvement of government. If you look at the bill, the commission is pretty independent. But at the same time, we are not earning money out of this whole privacy thing. But government definitely will be sponsoring this, funding this commission or authority, just like election commission or something else. So I think the consent part. Second important part was the localization of data. If you see the current bill, there are two clauses, two sections, section 14 and 15. They talk about the cross-border data flows. And they only activate in terms of sensitive personal data. Now, the, the sensitive personal data and critical personal data. What we have done is we put a thing over there that unregulated e-commerce platforms should be, the data should not go out of Pakistan. Now, this was a confusion for lots of companies. Even commerce division actually came to us and they were like, probably you'll be hurting e-commerce business for that. So what we have done is we have removed that unregulated e-commerce platform thing from that definition. Now, if you read that section 14 and 15 again, you will see that almost all sort of data is allowed to go cross-border with the consent of a data subject. So data subject allows it, you can take the data out of Pakistan. But at the same time, my recent visit to US, I have noticed and witnessed one part that, if the data goes out of Pakistan and if it's the data of citizens of Pakistan, and if there is any case related to it in our judiciary, and any judge directs you to get a data of certain case, once you go back to the social media platform or the big giant tech companies, they don't give you that data. So we are putting a mechanism over there that, if data is requested on certain condition and specifically by the judiciary, then they'll be bound to provide that data. But these things are already being incorporated, and I'm hoping that this will be finalized in couple of weeks now.
Thank you so much, Bilal. The next question, I think you've sort of covered it in your first answer as well, but just if we could get a bit more clarity, if you think you can provide it, because you just elaborated a very elaborate process of getting the bill, turning it into an act. तो जो timeline है around it even going to that first step of going to another to the law side of the Ministry of IT and then taking the further steps, what timeline does that look like? Obviously, approximately, if you can give us an answer around that.
देखिए, जब एक बिल बनता है ना, तो उसके लिए सबसे इम्पोर्टेंट चीज़ होती है कि गवर्नमेंट कितना इंटरेस्ट ले रही है. अगर गवर्नमेंट इंटरेस्ट ले रही हो तो फिर तो बिल्स 30 बिल्स भी पास हो जाते हैं, बहुत क्विकली चीज़ें हो जाती हैं. बट अगर इंटरेस्ट नहीं है, सो समटाइम इट टेक्स ईयर्स, पड़ा रहता है बिल. व्हाट आई हैव सीन कि इस दफ़ा गवर्नमेंट का इंटरेस्ट बहुत है इस बिल को आगे लेके जाने का. और मैं आपको एक चीज़ बताऊं कि यहाँ पर ये ऐसा बिल है जो कि सिटीजन्स के लिए, बिजनेसेस के लिए, उनको सपोर्ट करने के लिए. सो आई थिंक गवर्नमेंट, ऑपोजिशन, civil society, businesses, everybody is on board and everybody is pushing. So the timeline I see, that is from 6 months to a year, that I'm hoping that this bill will be passed.
Great, thank you so much. It clarifies a lot of things for everyone in the audience. Jehan Ara, what role, in your opinion, does the private sector have in ensuring privacy? And what kind of data protection bill would make sense given the tech industry in Pakistan? I know that you sort of addressed some of the points, but if you could just know.
So I think the private sector has a big role to play, but I would also like Bilal to cover how the public sector is going to be regulated by this bill, if at all, because we've seen in recent times the FBR data was hacked, and that worries me, because a lot of our information, including our salaries, personal data, everything is included there. So that is worrying. Banks, telcos, any kind of organization, tech companies, they all collect our data, and so I think that it is important for them to be regulated. Over-regulation is never something that I would advocate, simply because it stops people from doing the work that they're supposed to be doing. But private sector needs to self-regulate. They need to understand that any data they collect, they should have systems within their organizations to protect that data and the flow of that data and the destruction of that data. This, I think, not many people are doing. So I would like to see policies in organizations, whether they are private sector or public sector, which address this. It is extremely important because of the amount of data that is flowing through the system right now. And so misuse is a possibility at the best and worst of times. So I would like to see the private sector do that. And I think it's not the government's job. It is basically the job of trade bodies, chambers, organizations themselves, banks. I think banks are not doing that. We saw how many banks. I mean, I know that there is, and Bilal's absolutely right, there are several policies that cover each area, but they're all interlinked. So when you talk about the collection and protection of data, you also then have to cover the cybersecurity angle and the cloud angle, because all these three policies are linked. And so when you know that 6 banks or 3 banks, or I don't know what the number is, that their databases are not secure and that somebody has access to all that data, that is worrying. And what is being done? So by the banks and by the state bank to make sure that the right protections and cyber policies are followed. I think that is part of data protection.
Of course, thank you. Bilal, if you could just, I'll get to your next question, but also actually a very good point of interest that Jehan Ara has raised about the regulation around the public sector, because the private is heavily covered.
It's a very important thing. I mean, when you talk about this bill, this is not just for the private sector, it is for the public sector as well. For example, if you see that there is a chapter related to exemptions as well. We have not included any specific organization into it that, okay, this organization is exempted or the other one is not. Now, if you see the concept of this whole privacy bill, there are 2 important elements. One, who is collecting the data, so that is called as a collector, right? And then we have an organization or entity which is processing the data. So in case of an e-commerce platform, probably banks are the collectors and Daraz probably is a processor. So similarly, in case of, let's take the example of FBR, FBR is the biggest collector. Similarly, Nadra is another biggest collector. So definitely all of the public sector organizations will be coming under the ambit of this bill. You cannot actually give them exemption just because they are the government organizations. So we don't have any favoritism in terms of that, and we are not giving exemptions. Exemptions can be given on special cases, but again, that needs to be approved by the cabinet. It's not me, Ministry of IT, or the commission deciding that part. It is going to be cabinet which will decide that what sort of exemption can be given. So once every member of the cabinet will support it, definitely it is going to be the exemptions can be given. So this bill again applies to the whole of Pakistan.
Great, thank you so much for the clarification, Bilal. Our next question to you is, what was the scope of shareholders consulted in the process of drafting the bill? And how is the stakeholder feedback being incorporated into the bill? Because there have been several rounds. 2018, the first draft came out. 2018 saw two drafts, I believe, and then so on and so forth. So did that go about?
So first of all, 2018 में जब ये bill आया और फिर 2020 का जो हम, so I consider 2020 draft the first draft because I prepared it. So, but because again I have a reason for that, because 2018 draft and 2020 draft are almost 180 degrees. It's totally changed, and again we have done lots of consultation for that. So जब हमने इसको ऑनलाइन रखा, तो हमें तकरीबन 60 odd organization की तरफ से responses receive हुए. So what we have done is we have collected all those responses. हमने हर response को उनके relevant section के आगे रखा, और similarly जिसका उस section के against response आया था, वो हम लोगों ने अपनी Excel sheet एक manage की. Then हमने हर organization के साथ उनका फीडबैक जानने के लिए कि उन्होंने ये जो कमेंट किया है इसके पीछे क्या रैशनल है, क्यों किया है, इससे व्हाट वी आर गोइंग टू अचीव. समटाइम्स यू गिव अ कमेंट अबाउट सर्टेन थिंग्स because you don't have the clarity. So when you clear them certain things, उनके वो comments भी change हो जाते हैं accordingly. So this is what we have done. We try to have a conversation with them and try to convey our viewpoint and listen to their viewpoint as well. And it gives us an opportunity to see that what exactly is the need of the citizens, what exactly is the need of the civil society, and then businesses and the government. Now I tell you one important thing. The requirement of the government organization is almost 180 degree to the requirement of the international governments, international companies. Or similarly, our local companies have different requirements than the international companies. Now you have to strike a balance here. You cannot make everyone happy, right? So there are certain things which probably will not be acceptable to the international community, and there are certain things which our local companies won't be accepting. So you need to come up you need to strike a balance where you can have a 70 or 80% acceptability of the bill, and this is a good number to us. And this is what we have done. So we have communicated with all of them. We have discussed it with them, and then accordingly we have revised the bill. Now there are 3-4 important elements. Jehan Ara already talked about them. One was the cross-border data flows. That was the most important thing. Second was independence of the commission. That was another important thing. Third was the removal of a critical personal data, or if the government is not removing it, at least define it. So we have defined it, and these were some of the critical things which were, and then another scope of the bill, because our scope was little ambiguous, so we have put the clarity over there as well. So these are, if you ask me, that going through the views and the comments which we have received from the stakeholders, these were the 4 major elements where I have seen that there were voices. So we have addressed all these things, and we are hoping that it'll be acceptable to all of the stakeholders.
Thank you so much. I can only imagine making everyone happy with so many different stakeholders involved is quite a difficult task at hand. Jehan, do you think the private sector has been adequately consulted and represented in the process of drafting the current bill?
So I don't know what's adequate or what is not. I think the last consultation, I was a little worried that there was not enough time given for the consultation. Like, I think it was maybe a week that was given for consultation, and I think that's not enough, because people are not just sitting there working on the bill and sending their responses. So I think there should have been more time. But sure, I mean, I did not receive any intimation that there was consultation, although I believe it's on the website. We don't go and visit the ministry website all the time to find out what is open for consultation. Maybe we should. But I don't know what's adequate or what is not, but I'm glad to see the lot of stuff has been addressed. There are a couple of things that still concern me. One is the authority or the commission and its independence. So I understand that it's meant to be independent, but if it is appointed by the government and answers to the government, then what kind of independence are we talking about? Even if all the people in the authority are all from the private sector, if they still have to answer to the government, then I think it's not, in my opinion, it's not independent. It's still answerable to the government. Second thing is, I think I lost track of what the second thing was, but so I think if there could be some clarity as to the consultations that have been asked for and the suggestions that have been given, what if any have not been accepted and why? So I'm sure, I mean, these 4 areas that Bilal pointed out, definitely those were areas that were clearly the ones that most people were worried about. Were there any other areas, and why were, and if the government decided not to address them, what was the reason? Because then that leads to transparency. I mean, nobody is suspecting them. I think the intent of the bill is a very good one. and I'm generally very happy with it. But it would be good to have that transparency that, look, these suggestions were given by, business or civil society, and we have decided not to adopt them for XYZ reasons. That way it is a two-way conversation. Otherwise it's not.
Absolutely. I think it also comes across in when Bilal was explaining that the international businesses require a certain thing, and then the local businesses need something that's maybe 180 degrees opposite to that. So in conversation with you right now today, we're getting a glimpse into what the thought process was. But as Jehan Ara is mentioning, if there was communication around it, it just ends up, being a transparent process for all of us. And I'll let you also comment on that. And I will actually go ahead and then I'll just ask you the question.
So regarding a consultative process, if you look at the last session which we had on 5th of October, where we invited everybody online, and the purpose was that if, let's say, Digital Right Foundation have one viewpoint and Facebook has another viewpoint, and the government organizations has another viewpoint, they all are sitting on that one platforms, and everybody can hear everybody, right? And the purpose was that, we wanted to tell everybody, look, your viewpoint is actually being countered by this party. So we wanted to tell everybody that this is the difficulty we are facing right now. So the transparency which Jehan is talking about, I think we tried our best to actually be as inclusive as we can and as transparent as we can. And I think, this is the maximum we could do, that put everybody on make them sit on one table and let's talk about it. Because we really want, historically, if you look at the policies or the bills which were prepared, I usually call them a drawing room bills of the policies, right? You sit in your drawing rooms, you prepare, and second important thing, all of them, in fact, most of them were state-centric. They were not citizen-centric. So in this bill particularly, we focus on these two parts. It should not be a drawing room policy or the bill, and secondly, it should not be a state-centric, rather than it should be a people-centric bill. So that was our focus, and that's why there was so much consultation done. We tried to make them sit on one table, and this is what we have done. Another important thing, independence of the commission, that if they'll be reporting, I think if you look at all the commissions across, please suggest us that if not government is going to select them, who's going to select them, right? And what mechanism should we adopt to actually select those 7 people from the industry, how to put them on the board or in the commission. So if you can help us, if you can give us suggestion, maybe we can still incorporate that part. But right now, we have given this role to the cabinet, not just to one individual, not to Prime Minister, not to anybody else, but to cabinet. So once we say Government of Pakistan, after Mustafa Impact 2016, Government of Pakistan is cabinet. So all the minister has to decide it. So everybody will have the voice, and it is listened. This is what we have seen.
Great, thank you so much, Bilal. Yeah, if you tell us that, if you ask us for recommendations, I think Jehan and Nigit and I would just all be music to our ears. We'd love to pitch in, but also the next question that we have is around again the same Personal Data Protection Authority. Bill को enforce करने में what do you feel the role is of the Personal Data Protection Authority, and what kind of powers does the authority have to ensure accountability?
I have a long list with the powers we have given to the.
Very prepared.
Yeah. So I don't know, should I be reading it, because there are pages for that, because and I would suggest all of you to please look at those powers. And if you think that we have given too much powers to the commission, please let us know, because again, I tell you a concept and then probably you can look at in that way. You give powers to the commission because you cannot write everything in a primary legislation. That's why you give a power to them to make rules, regulations, right? So that's what we have seen. Okay, how we were, we were preparing bill, we used to run a use cases, certain use cases through the whole bill, and we used to see that, okay, it's stuck here, this section is problematic, and probably it can be addressed in two ways: either we fix it here right now, or we give a power to the commission. So where we could fix it, we did that, but where we could not, we given a power to the commission. So all the powers are primarily related to the flows of the data, to the rights of the data, how the citizen complaint will be addressed, how the breaches, if any occurs, it will be dealt with, and then there is another thing: formulate compliance framework and monitoring enforcement in order to ensure transparency and accountability. That is related to privacy, transparency, security guards, personal data breach, data protection, impact assessment, record maintenance, data audits, responsibility of data protection officer, processing of entities other than data controller, and there is a long list. So these are the frameworks they have to. If I won't write it, I was with few judges in past 2 weeks, and they were saying that most of the things we strike down just because you make certain regulations which are not referred in your primary legislation, and that's why we took that as an advice, and we try to incorporate most of the things which this commission would be requiring, and that's what we have done. We have given the powers to the commission.
Okay, fantastic. Thank you for clarifying that, Bilal. We have a question from the audience. I'll read out loud, and then we can see if anyone else has questions for Jehan and Bilal as well. I think this is directed towards you, Bilal. Please elaborate on the definitions of data controllers, data processor, and service provider. These definitions overlap with one another in terms of telecom companies.
मैंने वैसे वो याद नहीं किए definitions, so मुझे ज़ुबानी तो याद नहीं है, but जो data controller है as a concept मैं आपको बता दूं कि any entity which is actually collecting data. So controllers is the one which is collecting data. They are collectors, they are controllers. Telecom के scenario में I am not sure कि how is different, because for me regardless कि banks हैं, telecom है, government organization है, whoever is collecting a data, that is a controller, right? So अगर जिनका भी सवाल है, if they can elaborate it further कि what exactly they are asking, probably I'll be in a better position to answer. Because, please.
Yeah, so basically these definitions overlap in terms of telecom companies. So telecom companies collect data, they process data as well, and they're also recognized as a service provider in the 1996 Act. So this creates a bit of a confusion for us. That's why I wanted you to elaborate on these definitions.
देखिए अब यहाँ पर आपके आगे हैं दो roles. Number one is you collect the data, you become a controller, you have certain obligations that you have to follow, and if you're processing that data as well, तो आपके ऊपर फिर processors की भी obligations आएंगी यहाँ पे. Now overlapping में एक चीज़ ये होती है, मैंने एक example दी थी banks की और दराज की, उसमें ये बहुत कॉमन प्रैक्टिस है कि एक कंट्रोलर प्रोसेसर भी हो सकता है, सिर्फ टेलीकॉम के सिनेरियो में नहीं है. आप अगर करीम का सिनेरियो उठा लें तो वहाँ पर दे आर प्रोसेसर एंड कंट्रोलर बोथ. बैंक्स बहुत सी सर्विसेज आपको दे रहे होते हैं, एटीएम की सर्विस दे रहे हैं, तो बैंक आपका कंट्रोलर और प्रोसेसर दोनों हो गया उस सिनेरियो में. सो ये सिनेरियोज वेरी करते हैं. अगर ओवरलैप आप इफ़ यू कैन वेरी स्पेसिफिकली टेल के डेफिनेशन का ये वाला पार्ट ओवरलैप कर रहे हैं कंट्रोलर का प्रोसेसर के साथ, probably we can fix it, but as far as I'm concerned, I see that these definitions are the definitions जो कि internationally renowned है. हमने ये definition खुद create नहीं की है. If you go to GDPR या इंडिया के बिल को आप देखेंगे या ऑस्ट्रेलिया के बिल को देखेंगे, तो आपको वहाँ पर ये definition commonly सारे उसी इन्हीं definitions को adopt करते हैं. So we have not reinvented anything.
The ministry asked us for comments on this bill, and we've actually submitted our comments, but we're still waiting whether they'll be applied on telcos or not. a specific definition which could clarify where telcos stand, because we are also we're a service provider, we're a data collector, and we're a data processor as well. It will be over-regulated for telecom companies. So you have to follow regulations of data processor, data controller, and a service provider.
Absolutely. So which one do you want us to skip? Just because you're looking at one scenario. I don't see that it's over regulated. I see that you are giving more privacy rights to the citizens,
Right.
and that's the primary objective. If you look at the definition or the initial part of the bill, for us businesses comes second. The first priority is the citizens of Pakistan, and that's why we have given them rights, and probably you will see that businesses might get overly regulated, but we don't see it. There are many things which, if you're from Zong, because Zong is the organization which has given us extensive comments, and then Jazz and rest of the organizations as well. UFON has given us comments as well. But again, most of the things we have already incorporated. Few of the things probably we won't be able to do that because we see that they are contrary to overall concept, and that's why we might drop them.
Perfect. Thank you.
Thank you.
I think we can also take another question or two directed at either Jehan Ara or Bilal. Anyone has any questions about what they said or their field of expertise, they can ask the question. Just raise your hand. Absolutely.
Sir, what about constitution? Because there is no right of privacy mentioned in constitution. Is not there any amendment required? Because if we say about Article 14, this right is specifically mentioned about right of privacy in home. So if we want to go in great jurisdiction, especially High Court, which is the main jurisdiction point, in order to enforce this right, how can we go?
अच्छा, ये बड़ा प्योरली लीगल सवाल है. मेरा लीगल बहुत बैकग्राउंड नहीं है, बट मैं कोशिश करता हूँ कि आपको कर दूँ. प्राइवेसी के हवाले से हम लोगों ने देखें, ये अगर आप ओवरऑल देखेंगे तो आपके कॉन्स्टिट्यूशन है, फिर स्टैट्यूट्स हैं, फिर उसके बाद आपके रेगुलेशंस हैं, एंड देन रूल्स आते हैं. तो स्टेप वाइज एक चीज़ें आती हैं. वी कैन नॉट एक्चुअली गो फॉर एनी बिल इफ़ इट्स नॉट मेंशन्ड इन द कॉन्स्टिट्यूशन. कॉन्स्टिट्यूशनल अमेंडमेंट की ज़रूरत नहीं है. आर लीगल एक्सपर्ट्स हैव काइंड ऑफ रिव्यूड इट, एंड रिव्यू करने के बाद दे हैव एक्चुअली शेयर्ड विद अस दैट अकॉर्डिंग टू दिस क्लॉज प्राइवेसी की आपने इसका स्टैट्यूट बना सकते हैं. इसके अंदर एक बहुत सी डिबेट है कि वेदर मिनिस्ट्री ऑफ आईटी शुड बी डूइंग इट और नॉट, वेदर ह्यूमन राइट्स डिवीजन को ये करना चाहिए, किसी और मिनिस्ट्री को इसको करना चाहिए. बट यहाँ पर क्योंकि मिनिस्ट्री ऑफ आईटी टुक द लीड, और क्योंकि ज़्यादा डेटा रिलेटेड इश्यूज आजकल टेक्नोलॉजी के अंदर हैं, फिजिकल के अंदर भी होते हैं, although this bill will cover both, but Ministry of IT took the lead, और बहुत उसमें फिर हम लोगों ने human rights को भी engage किया, rest of the organizations. We received comments from Shri Mizari Sahiba as well. So वो सारी चीज़ें मैं incorporate कर दी हैं. It doesn't matter that it is going to be the bill जो कि Ministry of IT से हो या कहीं से हो. In the end इसको जब Parliament approve करेगी, it will be an independent commission. तो वहाँ पे मिनिस्ट्री ऑफ आईटी के अंडर इसका बनेगा भी नहीं. सो मैं एग्जैक्ट आपको क्लॉज शायद बता नहीं पा रहा बिकॉज मेरा उसका नॉलेज नहीं है, मेरा लीगल बैकग्राउंड ऐसे उस तरीके से नहीं है. आई एम मोर टूवर्ड्स डेटा साइड, बट डेफिनेटली आई कैन शेयर इट एग्जैक्टली. क्लॉज भी मैं आपके साथ शेयर कर दूँगा जिसमें आपको बता देंगे कि कौन सी क्लॉज आइन की कौन सी क्लॉज के तहत ये स्टैट्यूट बनाया जा रहा है.
It's actually Article 14.
Article 14 of please एक बार read कर लें. That is only
Privacy in the home. Yeah, you're right.
Privacy in the home.
Because सबसे बड़ी जो jurisdiction अगर हम कोर्ट के पास जा रहे हैं तो हमारे पास हाई कोर्ट की रेट jurisdiction है. Otherwise where we can go?
अब जो आपका जो हाई कोर्ट पे पॉइंट है थोड़ा क्लैरिफाई करता है. I don't think I'm understanding.
Actually इधर कोई वकील अगर है तो
जी
जी,
वो
जी.
ये कह रहे हैं कि जब आपके कोई राइट्स अगर आपको चाहिए होते हैं उसके लिए आपको कॉन्स्टिट्यूशन पिटीशन फाइल करनी पड़ती है, रिट पिटीशन फाइल करनी पड़ती है, और दैट रिट पिटीशन इज कवर्ड अंडर आर्टिकल कॉन्स्टिट्यूशनली आपको इन्वोक करना पड़ता है. तो if you invoke under Article 14, Article 14 is only privacy with respect to homes. So it is not with respect to the data privacy. So his question is that where are you going to file an appeal or a petition if you want to challenge something with respect to data protection laws?
If you don't find them to be what you want them to be?
No.
कौन सी कोर्ट की
कौन सी
jurisdiction
court?
में आप ये
तो उनका क्वेश्चन ये है कि what is your legal right with respect to the court जहाँ पे जाकर आप challenge कर सकते हैं?
I think Osama.
I think Sama can address this question.
ये Article 14 deals with dignity of man and privacy of home. तो privacy और dignity में एक बहुत intrinsic link है, right? So A, you look at that, and B, you look at the Supreme Court के जो precedents हैं. Benazir Bhutto case है, and then there's a Mustafa Impact
Mustafa
case,
Impact.
I think.
Mustafa
but
Impact is not covered in
that's
this.
sorry. तो उसमें जो है सर्वेलेंस को कवर किया गया है और उसमें प्राइवेसी पे भी उसने बात की गई है. So you can apply Article 14.
सुप्रीम कोर्ट की आपने जजमेंट जो पहले
Benazir
Bhutto
versus
case.
Benazir Bhutto की एक judgment है Supreme Court की around wiretapping, around surveillance and privacy. जो individual की expectation of privacy है, उसके around एक judgment Supreme Court की है Benazir Bhutto की case था. So you can just like look into that, and that is what is I think setting the basis for you to say कि एक individual की expectation of privacy अगर घर में है और अगर उनके for example wiretapping के through phone or communication की है, तो साथ ही साथ उनके when you shift all of that to the digital realm, if you ask me very specific technical वो I wouldn't know, but it reads into the fact कि आपकी जो expectation of privacy in the offline world है, you can assume the same in the online world as well. That is why data privacy, that is where it comes from. Because अब आपकी सारी data generation है और collection है, some of it is in the online world, but offline world, but mostly आजकल हमारी सारी online world में generate हो रही है, and that is why its protection is sort of mandated, and you can sort of make the law around it as mentioned.
सर इसमें सजेशन तो एक है अगर इसमें स्पेशल ट्रिब्यूनल्स या स्पेशल कोर्ट्स को इस तरह की कोई राइट दे दिया जाए
नहीं, बिल्कुल नहीं.
So what we can do is कि instead के हम ये discussion यहाँ पे इस forum पे जारी रखें, maybe we can have an offline discussion और वहाँ पर I can, you know, your suggestions are most welcome. हम उसको देख लेते हैं.
Well, thank you for asking your questions. We really appreciate them.